Good afternoon, all. This is Judge Goldblatt. We are on the record in Re Allegiance Coal USA Limited, which is case number 23-10234. We are proceeding this afternoon by way of Zoom, so usual Zoom rules apply, which I'm sure everyone knows by now. I am happy to pass the virtual podium over to Mr. Denny to take us through this afternoon's agenda. Mr. Denny.
Thank you, Your Honor. Can you hear me okay?
I can.
Very good. For the record, Robert Denny from Mars Nichols Auction Tunnel on behalf of the debtors. Thank you, Your Honor, for scheduling the hearing today. There are several matters on the calendar. We believe they're uncontested. We received comments from various parties of interest. We resolved any concerns, and we submitted revised orders. What I'd like to, so hopefully this will be fairly quick. What I'd like to do is give you an update of where we are since we came in a bumpy way, because we think we have some good things to report, and we're making progress. So after I'm done sort of going through their 3 or 4 points, I will turn the podium over, and Ms. Topper and Ms. Haga will take care of a couple of motions to the extent Your Honor wants a presentation and ask questions.
Okay.
Okay, very good. So first, Your Honor, I think at the last Zoom hearing, we said that Capstone had been engaged by the company. So we have Capstone Financial Advisory as well as investment bankers who have been engaged. As difficult a trip as it is to get there, they've been on site in Trinidad with the company this week. And that's great for us because it allows the company to work with them to develop a longer-term budget, to capture some of the things Mr. Lucas had identified, which is bankruptcy expenses, thinking about how far out, dealing with the assumptions, and making sure that Capstone is involved to validate the budget. We anticipate that the budgeting process will be completed next week, so that is good news. They are also working with the company and have been populating a data room, Your Honor, and obviously that includes the company's life of mines analysis, valuation materials, business plan, and the like. The company is receiving inbound calls for DIP financing and potential investors, and of course the investment bankers at Capstone are putting together what you would normally expect to solicit DIP financing to work with the potential DIP financing investor lenders so that we have a complete process. So if and when we come to the court, we can all be comfortable they've checked all the boxes. We are encouraged as part of that with Capstone, with the company and information we've obtained, the company is encouraged that we have third-party validation supporting both the company's methodology of mixing the coal. You heard a little bit about that earlier. So it's mixed from both mines. And then also the value ranges. Evaluation is not an issue for today, but just to give Your Honor a sense of what Capstone and the company are finding, plus with third-party information, you're looking at, we believe, $100+ million on a forced sale basis and $300 million on a normalized valuation and sale process. So that's not without prejudice to anyone's rights of arguing valuation. Hopefully we never have to come to that, but I wanted to give Your Honor a sense that the benefit of having Capstone working with the company and obtaining information is helpful for us in understanding as we map out direction, because as you heard at the first 2 hearings, we landed here without really a direction other than to survive. But we want to make sure all our counterparties and customers know we think we're putting together a path forward where we're going to continue to be viable, Your Honor. And that's why I give you that information. And again, it's an update. We are meeting the budget. As you saw from the, I call it the CSA motion, Ms. Popper will address the wholesale motion. That and the Saranki supplemental declaration, because we did file that to give you an overview, just the expanse of the operations and how long it takes to get from mining the coal to the filled container. You'll see that that's very important to our ability to get receipts of cash, the CSA type motion. And we have been talking to third parties. There was one identified in the motion. We're not sure where we will land with that party. We're hopeful. But that is going to be very important as we talk about meeting our receipts in the cash budget. Certainly, unless and until you come up with a DIP financing, a more traditional DIP financing, that will provide more of your working capital to get you through that 2-month period from digging until sale of the container. So that's where we are on that. Long way of saying we think we're going in the right direction for stabilization. And with that, it better enables us to have discussions with people like Collins. So I wanted to get to that next, Your Honor.
Okay.
We think we had a productive call last night with Collins Counsel about a path forward using cash collateral for a more extended period. Obviously, the budget is important to show them, but we were talking along the lines of getting from now, when we're able to get them information, probably next week, hopefully to a consensual form of order that would take us to the end of April. That's what we hope. We were encouraged, as I said, and we have work to do, and so do they, but that's the goal. If we don't get there, then we would have the contested cash collateral hearing. And in that regard, we asked Chambers for a new hearing date to accommodate schedules. And we were looking for the week of 3/29. We discussed that with Collins' lawyers last night. I believe Chambers indicated in his topper that Your Honor could hear us on the 31st, starting at 9:30 a.m. And that's fine. We haven't had a chance to talk to Collins, Mr. Lucas, and his folks. But we talked about that week. If there's a problem, we'll come back to Your Honor. But that's what we were shooting for. And that would allow us to deal with discovery as needed. So we talked about depositions. We talked about documents. That is all ongoing. And both of us understand if there are issues. Your Honor has said you're available to call balls and strikes. We hope not to bother you with that. But that's where we are. So we're hopeful on cash collateral, and we will continue working on that. Likewise, we have to keep working on if there is a contest. So,
right. And Mr. Den, just so the parties, so everyone knows, on the 31st, I'm available at 9:30. I do have something on for 1 p.m. And you know how these things are. I don't know if that's real or not real, but just so you know what we're looking at, there's the possibility that will be limited to, basically half a day. It seems to me, given how much Mr. Harvey and Mr. Lucas have taught me about these issues, I should be able to do this in half a day.
Yes, Your Honor. I appreciate the understanding of your calendar. We appreciate you giving us the time. As a consequence of the 3/31 hearing date, we would not be having a contested cash collateral hearing on the 22nd. There would be no need. So I think for cash collateral, we're either going to come up with something more global, or it could be if we can't get there by the time that the existing short-form cash collateral order expires, we may simply submit another one of those with the upgraded budget.
Got it, just to bridge it through to the 31st?
Correct. I'm just trying to let everyone know who's listening and Your Honor know how the pieces go. If we get to broader, then we'll extend it out to the end of April, hopefully. Otherwise, it'll be the shorter form, and we'll take it out to the 29th or somewhere 30th. And so that's how we see that going on cash collateral.
Okay.
The last update, Your Honor, is we understand from Mr. Fox, who has been very helpful, by the way, so I thank him for that, working with all these first day motions that we're filing, 10 days later. He's been very good. We understand from Mr. Fox, tomorrow is the deadline for questionnaires to serve on the committee. So in our mind, we expect that means there'll be a committee formed sometime next week or the week after. And of course, we understand they're going to come to us with lots of questions and information sharing, and we're ready to do that with them as well.
Okay.
I think I've covered everything I need to for sort of a summary of where we are. Do you have any questions of me? Otherwise, I'll turn the podium over to take care of the motions.
No, Mr. Denny, that was helpful, so I appreciate the update. So unless there's any reason that anyone else wants to be heard more broadly, I'm happy to allow you to pass the baton and proceed with the motions. Okay?
Your Honor, I see 36 participants on the bottom of my screen. I want to make sure Mr. Ronke is on. This is Zoom, and he's in Trinidad. And he said he tested the equipment. I just want to make sure he's on as I pass the baton. Mr. Ronke, are you on?
Yes, I'm on.
Very good. Thank you. Then I will excuse myself, Your Honor, and hand it over to Ms. Topper.
Okay, very well. Thank you, Mr. Denny. Ms. Topper.
Good afternoon, Your Honor.
Good afternoon.
For the record, Paige Topper with Morris Nichols Arsham Tunnel on behalf of the debtors in these Chapter 11 cases. Your Honor, I'll be presenting items 1, 2, and 3, working off of the second amended agenda that was filed today. And then I will hand sort of the baton over to Ms. Haga to deal with item 4 on today's agenda. But as an initial housekeeping matter, Your Honor, I would like to admit into evidence Mr. Ronke's declarations. There are 2. There was one filed, I believe it was yesterday, at docket item 73, and then there was one filed today at docket item 81.
Okay, is there any objection to the introduction into evidence of the 2 declarations that Ms. Topper just identified? Okay, seeing none, they will be admitted.
Thank you, Your Honor. So turning first to the item number 1 on today's agenda, that's the coal sale contract motion, Your Honor. In the ordinary course of business, the debtors routinely enter into sale and repurchase agreements with counterparties to sell coal from the debtors' mining operations to those counterparties until the stockpiles at the terminal in Alabama have been sufficiently accumulated, basically to fill a Panamax vessel. At that point, Your Honor, the coal is ready to be delivered to an ultimate buyer for a final sale. And so the debtors then at that time repurchase the coal from the counterparty for the final sale. Entering into and performing under these sales contracts, Your Honor, is critical to the debtor's operations. As was highlighted in Mr. Ronke's supplemental declaration filed today, it takes approximately 2 months of production at both the New Elk and Black Warrior mines to stockpile enough coal to fill that vessel and complete that final sale to a purchaser. During those 2 months, Your Honor, the debtors do require cash to operate the mine. That's where these types of agreements come into play. The agreements do provide the debtors with the necessary liquidity to continue mining, and as Mr. Denny mentioned, unless and until, the debtors receive debt financing, which the debtors' financial advisors, Capstone, are currently marketing. As I mentioned, Your Honor, the debtors do enter into these agreements in the ordinary course of business, so we do not believe that it's necessary under Section 363C to file, to have notice in a hearing with respect to entering into these. However, the debtors did file the motion out of an abundance of caution, and importantly, to provide comfort to the counterparties to the extent necessary with respect to these contracts. Without the relief requested, Your Honor, the debtors do believe that certain counterparties may be unwilling to enter into these type of agreements, which would result in an irreparable loss of revenue for the debtors at this time. We did receive several comments to the proposed form of order, Your Honor. We received first comments from Marco International Corporation. Marco was a counterparty on certain pre-petition agreements, and the debtors have been negotiating potentially a post-petition agreement with Marco. The changes made are reflected in the certification of counsel, and the revised order attached thereto are mainly to provide additional comfort for contract counterparties at the request of Marco. We also received informal comments from the Office of the United States Trustee as well as Collins, and those were resolved as reflected in the revised proposed form of order. And finally, I do want to note, and this is noted in the certification of counsel, but we did share the revised proposed form of order also with Warrior Met Coal Land, and they are, I saw their counsel in attendance on the Zoom hearing, Your Honor, and Warrior Met is the debtor's lessor under a mineral lease in connection with the Black Warrior mine in Alabama. So unless the court has any questions or would like me to walk through the changes reflected in the revised proposed form of order, the debtors respectfully request entry of the interim order.
Okay, thank you, Ms. Topper. I don't have questions. I've seen, obviously, the order and the like. Let me ask this. Is there any party in interest that would like to be heard with respect to the motion? Mr. Fox.
Good afternoon, Your Honor. Can you hear me all right?
I certainly can.
Good afternoon, Your Honor. Tim Fox on behalf of the United States Trustee. I just wanted to briefly indicate on the record that my office's informal comments have been resolved on the relief sought here today, and appreciate debtors' counsel in making those changes with respect to the relief. We would also just note that as a general matter, this is more of a comfort order. The language is largely consistent with those approved in other coal cases, and under the specific facts and circumstances here, U.S. Trustee has no opposition to the relief sought.
Okay. Any other party like the opportunity to be heard? Okay. Seeing none, I've seen the order. I think Mr. Fox is certainly right that it's that to the extent these are ordinary course purchase and sale transactions, it's ordinary course and you wouldn't need the order. I have no problem with doing it as a comfort order under the circumstances, particularly in a world in which there are some circumstances in which some people contend that purchase and sale transactions look like secured financing, and in view of the whole circumstances, it seems wholly appropriate to seek the order that you sought, and I think the relief sought is appropriate. So we will go ahead and enter that order.
Thank you, Your Honor. And let me just note, though, as another housekeeping matter, that the order does have blanks in it for the final hearing. So I do think maybe it makes sense to confirm the March 31st date so we can fill that in as well as the applicable objection deadline.
Okay, so I think we certainly can hear regardless of whether you succeed in resolving the continued use of cash collateral such that you don't need that date for a cash collateral hearing, we can certainly set that for what is in effect an extended second day, essentially, so that the orders can go out setting that hearing for March 31st at 9:30, and you can set the response date in accordance with the rules, and once those orders are uploaded, we will then go ahead and get them entered.
Thank you, Your Honor. We will do so. Turning next to item 2 on the agenda, Your Honor, that is Stretto's retention application pursuant to section 156C of the bankruptcy code. Because the debtors will have over 200 creditors or parties in interest listed on their creditor matrix, the debtors did file the motion to retain Stretto as a claims and noticing agent. Consistent with the claims agent protocol, Your Honor, the debtors did obtain and review proposals from 3 claims and noticing agents and ultimately selected Stretto. The debtors do intend to separately file a further retention application for Stretto as an administrative agent as well in these cases. We did receive some minor comments from Mr. Fox at the Office of the United States Trustee. Those were resolved by filing a note of the additional exhibits with respect to Stretto's retention application at docket item 74. So unless the court has any questions, the debtors respectfully request entry of the order retaining Stretto.
Okay, is there any party in interest that would like to be heard with respect to the motion to retain Stretto as claims agent? All right, seeing none, Ms. Tupper, I've reviewed the motion and proposed order along with supplemental exhibits, and am satisfied the relief sought is customary and appropriate. And again, subject to the order being uploaded, we are prepared to enter that order.
Thank you, Your Honor. That brings us to item 3 on the agenda, Your Honor. That is the utilities motion. The debtors are seeking fairly standard relief with respect to the utilities motion. The debtors are proposing as adequate assurance to fund a 2-week deposit into a separate account based off of the historical monthly average of payments that the debtors make to their utility providers for the utility services. There is one exception that I want to highlight for the record, Your Honor, and that is with respect to the debtor's electricity provider in Colorado, San Isabel Electric Association. It's noted in footnote 2 of the motion, as well as the list of utility providers, that San Isabel is holding a pre-petition security deposit in the amount of $311,500, which is equal to approximately 2 months of utility services from San Isabel. The debtors believe that they are current on pre-petition payments to this utility provider, and thus they believe that the pre-petition security deposit is sufficient adequate assurance of payment for post-petition utility services provided by San Isabel, and therefore we're not proposing additional adequate assurance for San Isabel in the form of adequate assurance deposit at this time. So with respect to the other utility providers, Your Honor, the debtors are going to set up that deposit. It will be in the amount of $9,385. The debtors believe that that separate deposit account is adequate assurance of payment within Section 366 of the Bankruptcy Code with respect to, again, the remaining utility providers. The debtors did receive informal comments, again, from the Office of the United States Trustee with respect to the proposed form of order for interim relief. We filed a certification of counsel with a revised order reflecting those changes at docket item 76, and those changes resolved the U.S. Trustee's comments. So unless the court has any questions, Your Honor, the debtors do respectfully request entry of that interim order.
Okay, is there any party interest that would like to be heard with respect to the utilities motion? Okay, seeing none, I've reviewed the motion and proposed order. I'm satisfied the relief sought is customary and appropriate, and we would be prepared, again, upon being uploaded, to enter that order on an interim basis.
Thank you, Your Honor. And with that, I'm going to turn the virtual lectern over to my colleague, Ms. Haga, to present item 4, which is the insurance motion.
Okay, very well. Thank you, Ms. Topper. Ms. Haga.
Good afternoon, Your Honor. May it please the court, Taylor Haga, Morris, Nichols, Arce, and Tunnel on behalf of the debtors in these cases. As Ms. Topper mentioned, I'll be handling item 4 on the agenda, which is the debtor's insurance motion. That motion was filed at docket item 6. By this motion, Your Honor, the debtors are seeking authority on an interim basis to maintain their existing insurance policies and premium financing agreements, including by paying on an uninterrupted basis all premiums, brokerage fees, deductions, and administration fees. The debtors are also seeking authority to renew, revise, or enter into new insurance policies and premium financing agreements as needed in their business judgment. In addition, Your Honor, the debtors are requesting that the court authorize all banks to honor all checks drawn on their bank accounts, as well as any fund transfer requests with respect to the insurance obligations. Finally, Your Honor, the debtors are asking for authority to replace any pre-petition checks or fund transfer requests that may be rejected. Your Honor, the debtors maintain various insurance policies in the ordinary course of business. These include insurance coverage for general liability, product liability, and automobile liability. For the policy period of 2022 to 2023, the debtors' annual premiums total approximately $2.3 million. The debtors estimate that they owe approximately $55,000 on account of pre-petition obligations, all of which is due and payable. Your Honor, a majority of the annual premiums are financed through first insurance funding pursuant to 5 premium financing agreements. Importantly, a failure to satisfy the debtor's obligations under those premium financing agreements could lead to the insurance policies being terminated or canceled. The debtors do believe that as of the petition date, they are current with respect to the obligations under those premium financing agreements. In connection with the insurance policy, the debtors also pay brokerage fees to their insurance broker. The insurance broker assists the debtors in obtaining necessary and cost-effective insurance policies. The debtors believe they are current as of the petition date with respect to those brokerage fees. Your Honor, the debtors submit that continuing to maintain their insurance coverage or premium financing, including by paying all pre-petition insurance obligations up to a cap of $55,000, is warranted under sections 363B and 105 of the Bankruptcy Code. because such coverage is necessary to preserve the value of the debtor's estates. Any lapse or termination of the insurance policies would cause significant disruption and distraction to the debtors. These policies limit the debtor's exposure to substantial potential liability. Many of them are also required by law and or by contract. In addition, Section 1112 of the Bankruptcy Code provides that a failure to maintain insurance that poses a risk to the public and or the debtor's estates is cause for mandatory conversion or dismissal of the cases. And finally, Your Honor, maintaining this coverage is necessary to provide adequate protection to the debtor's pre-petition secured lender's collateral. Based on the foregoing, Your Honor, the debtor submit that the relief requested is appropriate. With respect to the proposed interim order, which is attached as Exhibit A to the motion, we did receive informal comments from Crum and Forster. Crum and Forster is the insurance carrier under the debtor's D&O policy. We were able to resolve those comments through a revision to the proposed order. That revision is reflected in the revised proposed order filed at docket item 80 under certification of counsel. We also received questions from the United States trustee, which we were also able to resolve. And I'm happy to go through that revision or the United States trustee's question if the court would like.
So I'm sorry, so the form of order that was with the certification, that reflects the insurer's comments but not the U.S. trustees, is that right?
That's correct. The U.S. trustee just wanted clarification on a couple of points, which we clarified. Okay.
I'm happy to look at the form of order when it's uploaded. I don't think we need to take everyone's time to go through them. If upon looking at it I've got questions, I can reach out. But I think that if we're talking about the sort of usual kinds of clarifications, I don't think we need to detain the entire Zoom room walking through them.
Thank you, Your Honor. With that, unless Your Honor has any questions, the debtors ask that the court enter the order, the revised form of order filed in docket item 80.
Okay. Let me ask, is there any party in interest that would like to be heard with respect to the insurance motion? Mr. Bressler.
Good afternoon, Your Honor. Gary Bressler for Coleman Foster Specialty Insurance Company. We thank the debtor for making the change and also explaining to us that they will be able to pay the premium payment on our policy. We did ask one additional question. The order provides for payment of deductibles, but our policy doesn't have deductibles. It has a self-insured retention. Our understanding is nothing has been put in about the self-insured retention. For among other reasons, there aren't any claims right now the debtors are aware of concerning our client's policy, and if there is a claim, then the debtors will determine what they want to do with regard to the self-insured retention. And of course, my client reserves all our rights, claims, and defenses with regard to any issues concerning the self-insured retention. So we thank the debtor for the changes they made and for the explanation of the changes they didn't think were necessary that we asked about.
Okay. Thank you, Mr. Bressler. Is there any other party in interest that would like the opportunity to be heard with respect to the insurance motion? Okay. I've reviewed the motion and at least the form of order that was attached to the certification, and am satisfied the relief sought is customary and appropriate on the circumstances of this case. And upon the final form of order being uploaded, we will enter that order on an interim basis.
Thank you, Your Honor.
Thank you. So I think that brings us to the end of the agenda. Is there anything, any other matter on which the court can be helpful? Mr. Denny.
Thank you, Your Honor. No, I think we've completed the agenda. We're just going to keep pushing forward and hope to have more uncontested hearings in front of you.
That sounds fine with the court. Is there any other party in interest that would like the opportunity to be heard on any matter while we are all here? Okay. If not, thanks to all of the parties for the cooperation and progress that has gotten us to this point. encourage you to stay at it, and if folks need me, you know how to find me. I guess we have a second-day hearing and a penciled-in date on cash collateral for March 31st. So if necessary, we will see you then. And with that, we're adjourned. Thank you.
Thank you, Your Honor.